the arbitration that it demanded. That Treaty of Washington left nothing to chance. The parties agreed specifically to consider the result of the arbitration, and I quote, as a full, perfect, and final settlement of all the questions referred to the arbitrators, unquote. In short, Imperial Britain would have to abide by the conclusion of Paris. And so, of course, would Venezuela. And so it did for 6 decades, until 1962, when the government of Venezuela formally denounced the arbitral award of 1899 for the first time and reasserted the original pre-award claim, which amounted, as I have said, to almost 3/4 of British Guyana's, and now, of course, Guyana's sovereign territory. From the time that contention was first made, in 1962, the United Kingdom, British Guyana, and then sovereign and independent Guyana vigorously rejected it and affirmed in the strongest possible terms the validity of the award and the international boundary. Between 1962 and 1965, the parties engaged one another in a series of talks in which each tried to persuade the other of the correctness of their position, with no progress toward a resolution. But these talks did set the stage for a final round of meetings in Geneva in February 1966. On the eve of independence, Guyana participated in that conference. I did so personally as our country's Attorney General, and Guyana became a full party to the Geneva Agreement on attaining independence 3 months later, with its borders intact. As Guyana will show in these proceedings, Article 4, Paragraph 2 of that agreement clearly provided that where other means of resolution of Venezuela's contention of nullity failed, the Secretary General of the United Nations shall choose another of the means stipulated in Article of the Charter of the United Nations. At the Geneva Conference, it was Venezuela that affirmed that procedure. So this is the background to the case that is now before the court. And I hope that you, Mr. President, and honourable members of the court will regard it all as somewhat helpful context for the matter you are called upon to decide at this stage of the proceedings. That matter, this hearing, is really about the court's jurisdiction. A jurisdiction specifically to consider the claims asserted in Guyana's application. Most importantly, its submission that the arbitral award of the 3rd of October 1899 continues to be valid and binding on the parties. Guyana's case As you will have seen from its memorial on jurisdiction, and as you will hear from its advocates today, is based on the plain text of the 1966 Geneva Agreement, by which the parties expressly consented, one, to accept the decision of the United Nations Secretary General on the means of settlement of their dispute over the validity of the 1899 arbitral award, including judicial settlement by this court. And two, that the dispute shall be settled by the International Court of Justice, if that be the means of settlement chosen by the Secretary General. It is unfortunate that Venezuela has chosen not to participate in these hearings. Undoubtedly, it would have been more helpful to the court for both parties to appear, to fully present their arguments in the first round and respond to each other in the second. But at least the court has not been left to speculate as to what Venezuela might have said had it appeared in this great hall of justice. By the date fixed by the court, namely the 18th of April 2019, Venezuela failed to file its counter memorial, but it promised, and I quote, information in order to assist the court, close quote. And on the 28th of November 2019, it submitted a 56-page memorandum to the court, accompanied by a 155-page annex, setting out the basis for its objections to the court's jurisdiction, and very much more besides. Guyana will respond today to all of Venezuela's contentions regarding the court's jurisdiction, as they appear in those written documents. And we will demonstrate beyond any doubt that they are entirely without foundation, and that the court unquestionably has jurisdiction to proceed to the merits phase of the case and adjudicate Guyana's claims. Mr. President, almost 60 years of Venezuela trying and failing to despoil the sanctity of the Treaty of Washington and to nullify the Paris Award. The Secretary General of the United Nations indicated to the presidents of Guyana and Venezuela in these words, and I quote, "I have fulfilled the responsibility that has fallen on me within the framework set by my predecessor, and significant progress not having been made toward arriving at a full agreement for the solution of the controversy, I have chosen the International Court of Justice as the means that is now to be used for its solution. That is why we are here, attended by the faith of the people of Guyana in this International Court of Justice and in the rule of law internationally. Mr. President, members of the court, it remains for me only to outline the scheme of presentations that will follow for Guyana. They are as follows. Professor Payam Akavan will address the court on the origin of the dispute and the circumstances leading to the conclusion of the 1966 Geneva Agreement. Mr. Paul Reichler will then follow with a careful textual analysis of the Geneva Agreement and its dispute resolution provisions, including its conferral on the Secretary-General of the authority to make a final and binding decision on the means of dispute settlement that the parties are obligated to pursue, including, if he so decides, judicial settlement by the court. Professor Philippe Sands will follow him with a review of the implementation of the Geneva Agreement, including the parties' reaffirmations of it and the Secretary-General's acceptance of the authority conferred upon him and the manner in which he exercised that authority. And finally, Professor Alain Pillet will address the Secretary-General's ultimate decision that the dispute over the validity of the 1899 arbitral award shall be settled by the International Court of Justice, and the consent of the parties, including Venezuela, to judicial settlement of the dispute by the ICJ. I thank you, Mr. President, and honorable members of the court, and I ask that you now call Professor Akavan to the podium. Thank you.
I thank the co-agent of Guyana for his statement, and I now invite Professor Payam Akavan to take the floor. You have the floor.
Mr. President, distinguished members of the court, I'm honored to appear on behalf of Guyana in this proceeding on jurisdiction. I will be addressing the circumstances leading to the conclusion of the 1966 Geneva Agreement to resolve the controversy over the frontier between Venezuela and British Guyana. It is Article 4, Paragraph 2 of that agreement, in combination with the 30 January 2018 decision of the UN Secretary-General, which establishes the court's jurisdiction. The history of the controversy demonstrates that the dispute between the parties was and remains about the legal validity and binding force of the 1899 arbitral award. Beginning in 1962, Venezuela claimed that the award was null and void, whereas the United Kingdom and Guyana have maintained that it is valid and fully binding and effective. The parties held clearly opposite views on the validity of the 1899 award, and that was the dispute dividing them. As Mr. Reichler will explain, the object and purpose of the Geneva Agreement was to obtain a final and binding resolution of that dispute. My speech will consist of three parts. First, I will provide an overview of the 1899 award that established the boundary between British Guyana and Venezuela. Second, I will address Venezuela's contention beginning in 1962 that the 1899 award is null and void. This was the basis for its repudiation of the boundary and its claim to almost 3/4 of Guyana's territory. Third, I will address the parties' exchanges between 1963 and